prohibitory requirements in an order. So he says, then each new breach of the existing order is a fresh breach that gives rise to separate committal orders. In paragraph 35, he considers a positive or mandatory requirement in an order by reference to in re A. And if you could please read that paragraph. And you see the conclusion at letter H. And then in paragraph 36, you see a summary of the case Kamari and Jalal, which you'll notice in the authorities bundle at tab 4. And that was the case where the defendant was ordered to deliver up clothing and jewellery by a particular date. And then further orders were made when they failed to comply. And you can see that the key passage here then is in paragraph 37, where the court holds that in the case of prohibitive injunctions and in the case of mandatory injunctions requiring positive action, such as the disclosure of information, the court can make successive orders notwithstanding a past failure to comply with an identical request. And a breach of that order will be a fresh breach with the possibility of committal proceedings. And if you go with the page and just cast your eye over 44 to 47, this deals with committal, that a further term of committal was legally possible and fully justified. So was the judge making yet another order for disclosure. The coercive effect of seeking compliance had not yet run its course. And if you could then please look at paragraph 51, the judgment of Lord Justice Hughes. So the 3 points we take from the case are, first of all, the court obtained jurisdiction over the father by service of an application on him for an order that he disclose the information, the application being made by the wife. And in this case, so too, the court properly obtained jurisdiction over Mr. Vick through the Part 71 order. Secondly, the court retained the jurisdiction to remake the order in the same terms with a different deadline on multiple occasions. And thirdly, the court made successive fresh orders of this kind, notwithstanding the father having been convicted of contempt and having served his sentence in respect of the same mandatory obligation. The only point of distinction is that the father was in the jurisdiction when the subsequent orders were made against him, but that's not a distinction that matters when the court continues to have jurisdiction over Mr. Vick in connection with the CPR 71 order. Now, Mr. Vick says that these cases are different because there had been no change in the factual situation in these cases, and therefore the court had the same power all along. That's his skeleton at paragraph 37. We say the same is true here. It may be that what Mr. Vick's actually saying is that all these cases are not ancillary or not examples of ancillary or incidental orders. And what all we can say is that the cases don't discuss the precise nature of the jurisdiction being exercised, but what they do show is that where the court has jurisdiction to require someone to do something and that person doesn't do it, the court will seek to render its order effective by making new orders requiring that thing to be done. So the remaking of an order is an important part of the court's armoury, and therefore there's no reason why it shouldn't be within the scope of the inherent jurisdiction, or an order shouldn't be regarded as incidental or ancillary if given it supports the purpose of the original order.
But if one can't tell from this case because it wasn't addressed, that there was any difficulty jurisdictionally in making a fresh order in the sense of one which was a new exercise of the original jurisdiction on each occasion. How does it help us very much? I mean, what it shows is if you have jurisdiction to make a repeat order, it might be because you're exercising the original jurisdiction again on each occasion, or it might be because you're exercising an incidental jurisdiction in relation to the first order. And,
So
and how does this tell us that it's one of
it shows you 3 points. The first is it shows you that the court doesn't hesitate to remake orders as part of its armoury in enforcing an order for a relief that hasn't been complied with, and that we say actually cuts across what the judge found in her judgment as part of her reasoning around paragraph 100. The second point it tells.
Does it? She was addressing the fundamental position that she couldn't exercise an Order 71 jurisdiction herself as a fresh exercise of jurisdiction. So for her, the question of whether you could or couldn't do something that was effectively remaking the order depended upon whether remaking the order was incidental to the original order, ancillary, and so on and so forth. That just isn't an issue which this case tells us anything about, is it?
Well, what I would say is in this case, it's quite clear from the passages I've shown you that the way this was regarded, that there may be successive and consecutive contempts to comply with a mandatory order, positively not to do something. And so the judge seemed to, certainly Lord Justice Hughes, and also I'd suggest Lord Justice McFarlane, seemed to be regarding this as a continuing failure of the original order, and they were making the orders for the same information to be provided at new dates, and each order could be a new contempt. And what that shows is that when the judge says that talks about the usual means of enforcing an order, not including remaking an order, putting the jurisdiction question to one side, one would have to suggest that you're undoubtedly enforcing the original order by making further orders for the same relief.
Well, not necessarily. You might just say, I'm just making another order. You haven't complied with it, I'm going to make another order.
Well, my lord, I would suggest that having the way it's phrased in paragraph 51, repeated omissions to comply with a mandatory order positively to do something.
That's a single order. You can have successive contempts. The first half of the paragraph says if you're ordered to not to do something and you do more than one positive act, then that can be a contempt each time you do something that you've been prohibited by doing. If there are omissions to comply with a mandatory order positively to do something, a mandatory order, you can have repeated omissions. They may be repeated contempts, single order. It's not really telling you anything, is it, about what the position is with fresh orders?
I understand that one, and I won't press it, but I was just going to say when it said similarly, the authority of Kamari and Jahal, to which I've already made reference, contemplates a failure continuing, and then a fresh order is made on each occasion, but the failure is continuing.
Yes, but the failure does continue as a matter of fact. If you don't do something and you don't do it, you're still not doing it.
Yes.
That does not tell you whether making a fresh order is a means of requiring you to do something you haven't done, or is a means of enforcing the order that was made first time round. And you want to say it's the latter, but I agree with my lord that it simply doesn't address that
I
question.
want to say it could be both, and that one should approach it on the basis that it could be both.
Well, it could be both in this case, and that's the problem, because it can't be both in the case that we're dealing with.
Well, let me then show you. I wanted to show you the various authorities because I wanted to show you Roland as well,
Yes.
which is at tab 20. And in that case, Mr. Stanford was given an immediate committal order for breaching a Norwich Pharmacal order.
Sorry, just give me that. Tab 20, did you say?
Yes, thank you.
Yes.
And he was given an immediate committal order for breaching a Norwich Pharmacal order, and he made a discharge application very shortly after being committed, and you can see that at paragraphs 11 and 12. Sorry, 1 and 2, I beg your pardon, 1 and 2. And he'd not yet fully complied with the original committal order because he'd not sworn and served an affidavit setting out full details of how he'd come into possession of an electronic archive of documents and related matters. And you can see that at paragraph 15. But he had purged his contempt in relation to other parts of the original order. The judge decided to order his release, but at the same time remade part of the original order with which Mr. Stanford had yet to comply. And you can see that at paragraph 26. Now, the passage repays careful reading because in the second sentence, the judge says, I will give Mr. Stanford further time to comply with the second part of paragraph 3 of the April 2021 order. So, in other words, he regarded Mr. Stanford as still being bound by the April 2021 order insofar as he had not complied with it. And he requires him to comply with it by means of a further order to ensure the first was rendered effective. And on page 528, paragraph 29, he holds that Mr. Stanford has satisfactorily purged his contempt and orders his release and discharge. And again, this was an order made of the court's own motion. The claimants didn't seek it, and it was not part of Stanford's discharge application. So the judge here treated the power to remake this aspect of the order as an ordinary and obvious part of the court's enforcement arsenal to secure compliance with an existing order that had been breached.
Sorry, but where do we see that?
Well, that's
He's going to make a further order.
That's right.
Further order is going to give him a different time
That's right.
at which he has to comply
In order
with something that was in the first order.
Exactly. It's a further time to comply with the second part of the order, and he'll do so by means of a further order. But he's using the further order to ensure compliance with the first order.
Well, there's been an order. He's supposed to have done certain things by a certain date. In this respect, he's failed to do so. The judge is going to make a further order.
That's right. The
effect of which will be that he's got to do that bit that he's failed to do by a subsequent
That's right.
time. Now, I can see you can say, well, this is authority for the proposition that
you can remake part of an order.
You can remake part of an order, but why do you say it's enforcing as opposed to just making a fresh order?
Because he says that Mr. Stanford has satisfactorily purged his contempt. So the further order he's making is to enforce the original one, which was upheld by contempt. And he makes a further order to ensure enforcement with that order, then says because he'll do that, he purges his contempt.
Well, no, what he says is purge his contempt by expressing contrition and having complied with the April order to the extent I have identified. He clearly is not, though, saying, and because I'm giving him more time to do the rest of it, that's a purging.
But he does, because he says, if you look at it, he says he's not complied with the order.
Yeah.
So you can see that when you look back in the judgment. So para 14, as I've mentioned, it falls into two parts, the order. The first part requires provision on affidavit of full and accurate details. The second part requires etc. And he says, as to the first part, I accept this goes further than previous efforts. I therefore consider, this is the bottom of 15, Mr. Stamford has sufficiently complied with this on the first part.
Yes.
The second part, he says he hasn't provided any more detail, but he says he can't provide it while in prison. And in response, the claimants say, no, what he's done is inadequate and he's not trying. And 20, I propose to deal with the issues taking account of his present position. And he said 21, I'm required to ask, has he done all that's he reasonably can? 22, I found this a difficult question because I want to be fair to the claimants. And on the other side, he says he can't do it unless he's released. He says, I'm on his side because I hope his attitude's changed. And then he says, so what I'll do is give him further time to comply with the order and purges his contempt, even though he said he hadn't complied with the first order. So the second order can only be in trying to get him to comply with the first order. So, my lord, what I would say is, what one can see is the court doesn't hesitate to make orders for the same relief. And in one sense, however that's framed, it's remaking an order the first time round, whether that be, you can, from the example my lord, Lord Justice Popplewell gave of a Moravian injunction or returning a child. The next question is, what's the status of those orders? Are they enforcing the first order, or are they entirely new freestanding orders? And I accept that in the first case, it could be that they were new orders. It equally could be that they were made to enforce the first order. And certainly, you could say the same about a Moravian injunction. The fact is that the court has to start from the point of ensuring that when it makes an order, this is the Beckor point, there is no point making an order if it cannot be enforced. And the armoury that the court has to make sure orders are effective can include, and that's as high as I need to put it, ordering a subset of what has not been provided to be provided by a further date. And that doesn't require the court to re-establish jurisdiction over somebody, because if the court's trying to make its own order effective, it already has jurisdiction inherent within the order it has already made, assuming that order has not been discharged or spent. And in this case, we suggest that it's obvious it hasn't been discharged or spent, which might have been a different argument, because of what was said by Mr. Vick himself and the sentencing hearing and the committal order. So,
well, nobody treated it as if it was spent.
Exactly, my lord, my lady.
And indeed, it seems to me that conceptually there's a difficulty in saying it's been spent if it's not been complied with. Exactly. I mean, if the whole purpose of the contempt procedure and the fresh order is to try and ensure that Mr. Vick does what he was ordered to do the first time round but failed to do, which was to answer the questions truthfully and produce certain documents, then if he hasn't done those things, how can the order be over? It can't be it hasn't been satisfied.
Exactly.
So conceptually, to me, I have difficulty with the argument, well, the order's spent, it's all gone off. Regardless of how one might read Mr. Justice Cook's judgment, which is a bit, there are certain tensions in it, maybe, with that argument.
Well, my lady, I think all that Mr. Justice Cook was saying was that his examination for that day had come to a close, and that we were keeping him in the witness box and holding him over, and that we couldn't just apply on the hoof for a committal order. We had to do it on proper notice to him.
I think he was clearly saying that, but in the passage that troubled my Lord Justice Nugee, before lunch, about where effectively he says you can either go down the contempt route or you can ask for further questions. I don't think he was envisaging that you should actually have to choose between them in the sense of being put to a formal election.
No. I
I
don't
think what
think
he was
so.
suggesting was these are the options that are open to you at this stage, and it's up to you to decide what you want to do.
That's right, my lady, and I think that may be because there was a debate in front of him as to what the appropriate procedure was. And I think, I mean, it's a long time ago, but I recollect asking the judge what he had in mind for the appropriate procedure. And he was basically saying, well, it's up
And
to you.
you.
I'm not going to tell you what to do. You've got to make your own mind up. We could check that. But I think the other point, my lady, I would make is that assume Mr. Vick hadn't turned up for the further examination and he had gone to prison and served his sentence. It would have been open to the bank to say we are entitled still for him to comply with the order that was made, and we still regard that as an extant order, and we'd like a further examination, please, under that order to enforce it. So it seems to me that the election couldn't have had the effect of rendering the Part 71 order spent.
Well, it would be tantamount to saying that contempt procedures a contempt procedure is effectively the only way you've got of enforcing compliance with the order, and that can't be right.
And that's exactly right, and that's why I referred to Lord Justice Gross his comments about it being a incident, because I thought that was quite important. And there are other ways the bank can enforce and did enforce by trying to realise assets, for example, it found. It's not limited to one method. So, my lady, that takes me to my third point, which was the judge's views about the narrow scope of the inherent jurisdiction were infected, we suggest, by the finding that the original order was on the outer limits of the Part 71 judgment, and that's at 111. And Mr. Vick suggests that this didn't form part of the judge's reasoning, but it did if one looks at paragraph 110 to 111, because the reason why the judge found that she didn't want to take a broad view of what was ancillary was because the original order was at the outer limits of the Part 71 procedure and Mr. Vick was only fortuitously in the jurisdiction. And so it does appear that that was a reason for the decision on ancillary. And what we suggest is that that was the wrong approach under Masry, and as made clear by Lord Justice Gross in the 2018 decision at paragraph 57, and that's in the supplementary bundle at tab 28. I see no sign of any exorbitant jurisdiction being exercised in this case, keeping well in mind the indisputable jurisdiction over Mr. Vick in respect of the Part 71 order. And that was upholding the application for committal.
But once you've got jurisdiction over somebody by whatever fortuity, because they happen to be within the jurisdiction you serve them, and the fact that they go out of the jurisdiction again doesn't stop them being subject to the court's process.
Indeed. And that would be the mischief here, that it would mean that anybody who left the jurisdiction, one had to establish jurisdiction over all over again every time you tried to enforce the order.
Well, also one comes back to, I think it was Lord Justice Ricks's observations about the fraudster's charter,
Yes.
effectively, that one could frustrate a court order by refusal to complying with it, just complete refusal to comply, divesting oneself of an interest in the company so that you're no longer cross-examined as a director, and disappearing to Venezuela or wherever.
Exactly. And so, my lord, that's why we say that insofar as that informed the judge's finding, it was wrong. Now, it may be that what the judge was saying was the point that Lord Justice Nugee put to me, which is, why wouldn't you have just applied if Mr. Vick was in the jurisdiction and was an officer for a fresh Part 71 order? And are you therefore trying to go around the back door because of that? And the answer to that is no, because what we're asking for on the face of the order is compliance with the 2015 order. And it's not We're not seeking a wide, fresh-ranging order to enforce the judgment debt. And then the question is, why are we entitled to that, beyond the point that the old order has not been complied with? And the reason we're entitled to it is because we know there is information there that is missing, partly because of the evidence that you have before you in the bundle from Mr. Robinson about various boxes of documents that came to us, and partly because of Mr. Vick's own evidence that he was beginning the process of pulling together the information he should have given. And
I'm not sure that answers the question as to whether you have to invoke an original jurisdiction or an ancillary one. If a court makes an order that a parent is to bring 3 children back and the parent brings one of the children back, and you then seek a subsequent order that you bring the other 2 children back, that still tells you nothing about whether at that stage it's exercising an original jurisdiction or an ancillary jurisdiction.
That example doesn't, my lord.
Why
But the
does
example,
you say we're entitled to all this information for the purposes of enforcing the judgment against SHI.
of what he should
But that's what
have
we
given.
asked for originally. We have had some of it. That's the one child, but we haven't had the other 2 children's worth. So now the order we're seeking is narrower.
But it's a slightly different example, and it doesn't work with the children, because what we're really saying is we'd like the children age 7 when you should have given them to us, not age 9. We're saying we want the information you should have given us then, and we're not saying that anything now relevant to enforce the judgment debt as at this date, beyond the parameters we've identified. Now, things may have moved on, and he may need to answer questions with more up-to-date information, but that we are seeking what should have been provided in 2015,
But
with some limitations around it.
are your topics, I don't know enough about them, but are your topics not topics about whether those matters cast light on the current asset position
They
of
they
SHI?
are, and I accept that, but they stem from for example, Mr. Vick may have information now about that would be relevant to the judgment debt that would not fall within those topics. Now that would be the subject of a new Part 71 order if that was the case. We are limited to what we've asked for, which arose as at that date and the knowledge we had over the topics.
Are you limited to what he knew then?
No, because things have moved on. I accept that. Because we couldn't be, because in a sense, he was ordered to provide the information at 2015 and lied, and we now are entitled to ask about what he should have told us, and that may well be more up to date. But we just don't know, my lord, at this stage, what he doesn't know. What I can give you a clear example is that if there's a whole new topic of assets, it's not caught by this order. So it's undoubtedly trying to get to what we asked for in 2015.
But suppose in these respects, which Mrs. Justice Mulder has identified, he's lied about not knowing anything on any of these topics.
Yes.
And suppose that at the time when the examination took place, he did know a certain amount about these aspects, but he now knows a great deal more about it. What you're seeking is an order that he tells you what he now knows about it, is that right? Not just what he then knew about it.
Yes.
Does that reflect, therefore, an aspect of the order which is not simply getting him to comply with what he was obliged to do in 2015, but an additional Part 71 relief?
It requires him to comply with the order to provide full information, and the order will be at this new date, and that's the answer. So it's
He has to comply with the order. The order was to give full information. At the time when he was obliged to provide it, he could only give the full information which was known to him then. If he is required to provide full information now, you can't artificially draw a distinction between what he knew then and what he knew now. It's the same compliance.
I accept that, and we say it is the same compliance. What we say we're not entitled to do is go stray beyond the bounds of the topics we've
So
identified.
if, for example, it came to light as a result of something he said, that there was a whole raft of assets out there which were never even mentioned or envisaged or part of the original order, you accept that in order to get him to give further information about those, you'd have to go through the process of a fresh order.
I do, and that's the distinction. And I do accept that. So that's why it's not a fresh order under Part 71, because that would entitle me to ask about everything.
But why is ordering him to disclose now something which he wasn't able to disclose then, and therefore wasn't obliged to disclose then, not a fresh form of relief?
It's not a fresh form of relief, my lord, in the sense that it is the reality of asking him to comply with the order now that he failed to comply with then. And that is
Not my hypothesis is that he may have failed to comply in relation to these topics generally, but he's now being asked to comply in relation to matters which did not necessarily form a failure then, if the scope of the new obligation is what he knows now rather than what he knew then.
Yes, but Mr. Justice Cook changed the date, as was pointed out, I think, at the beginning of the hearing, and that didn't have a bearing on the scope of the relief. It just had to, it was when the examination was conducted.
You get this all the time with Moravas. I mean, time moves on, people's information moves on. Somebody didn't comply with an ancillary disclosure order in a freezing order. You can't then say, well, I want to. I'm not enforcing the freezing order by requiring him to give disclosure now. I just don't get this point, that there is this distinction between what you know then and what you know now. You are either giving the information or you're not giving the information, and you can only give the information by reference to what you know at the time when you're required to disgorge it.
I think that's right, and I think that's the approach Mrs. Justice Mulder was also taking.
Well,
She wasn't trying to suggest that in order to remedy his contempt, he had to give the information missing as at 2015. It's as at the date of the examination, and that is enforcing the order to give full information about the judgment debt that was not complied with. And I suppose the rationale, my lord, is that the hypothesis is if he'd given the information in 2015 that he knew then, we may have enforced. So his breach has led to our detriment to the situation now where things have moved on, and therefore to do anything else would be to effectively sanction his breach because he's evaded. And it wouldn't, and the reason it's not a fresh order is that would be just allowing somebody who'd evaded the breach to then say, right, you have to keep coming after me each time I evade it to get a new order, because it's a new date.
suppose that you have a respondent who does comply with the order in revealing everything that he then knows on the topics which he or she is examined. Would you be able, under the ancillary jurisdiction, to ask further questions if you had reason to believe that as a result of subsequently acquired knowledge, he had further relevant information?
I don't see why not, my lord. We'd have to apply for an order that circumstances had changed, and in order to properly render effective the first order, because he told us new things, we would want to ask further questions.
My example assumes no breach of the first order.
Yes.
So he turns up on the first occasion and answers the questions truthfully, so far as his then state of existence is, then state of knowledge is. Nevertheless, you say if his state of knowledge changes, you can get an ancillary order, or does your argument depend on the fact that there was in this case, a breach?
Can I put it like this, Margaret? It's certainly cleaner where there's a breach, and it's definitely clear in that case. I accept that where there's been compliance, it might depend on the nature of the information that had come out.
Well, isn't there a simpler answer, which is that once you've complied, the order's spent?
Yes. Yes.
He's asked to
Fair.
comply. He does comply. That order has been fulfilled. It's served its function. It's finished.
Yes.
And so, if further information comes to light after that, you've got to go through the process afresh. But if it hasn't been complied with, it isn't finished. There's unfinished business out there. And as I understand your argument, the unfinished business has to be addressed by what the person knows at the time that the compliance order is made, because it would be unduly restrictive and artificial to go back to what he knew 20 years ago or 10 years ago or however long ago it was that the order was originally made. That would be totally there would be inutility in making an order of that nature.
So that's exactly right. We think it just wouldn't be practical or and no utility. In answer to my Lord Justice Popplewell's question, Lady Just Sanders is right that if the order's been spent, then that's the end of it. I was hesitating because I can see a scenario in which the person answers truthfully, but the all information criteria might be said to have been stretched because his answers had shown that there was in fact more information that he could have given. And I can see that there may have been an argument that this order wasn't spent and there should be an ancillary order. That's why I was hesitant. But I think the clearer answer is undoubtedly that if there's no breach, it's likely that the order's been spent. And that's the distinction. And the other point, my lord, which takes me on to my fourth point about the judge's judgment and why it was wrong, is about the imposition of unnecessary limitations on the court's powers by the judge's analysis. And it's important to stand back in the sense that the whole point of the Part 71 order is to try and assist a party who has a judgment to be able to enforce its judgment. And the officer is required to give information to assist with that process so that a debtor can't hide their assets. Now, here, to suggest there are limitations on what the court can do where a debtor has evaded and has said that they have information because of debates about whether it's truly ancillary, what the format should be, we suggest isn't the right approach. And that's why we said the real test is it just and convenient to enforce the order, rather than getting into a narrow definition of ancillary or remaking orders or on the outer limits. It's a very broad power. I'm not suggesting it can be exercised without reference to what the purpose of the original order was. And I'm not suggesting it can be exercised without reference to fairness and the overriding objective. But the judge's approach, we suggest, took the judge into some tangles as to why the order was not ancillary. And I think that's relevant for this court because actually once you can see how difficult it was for the judge to comprehensively define why it wasn't ancillary or incidental, you can see that that wasn't the right approach. May I briefly just check that I have covered off the judge's other reasons, because I gave that as her fundamental error. But at paragraph 27.1 of Mr. Vick's skeleton, it's suggested that the judge found that if the requirements for a Part 70 order were met, the bank could have obtained the order it's seeking and it wouldn't have been dependent on the original Part 71 order. And the judge also said, as you'll remember, and this is something Mr. Vick relies on at paragraph 27.2, the judge also said at paragraph 97 of the judgment that the order wasn't breathing life into the original order and that the Part 71 order would be superseded by the new order. Well, all of those points, we say, fall away if one analyses things as has been suggested by Lady Justice Andrews and I'm submitting, that the order hasn't been spent and therefore there's no case of this being a new Part 71 order. The judge also made a number of points around paragraph 90 of her judgment that the new order didn't look like an ancillary order or it hadn't been expressed as such, or about the drafting of the application and the evidence. again, we suggest none of that really matters. And it may be the judge then anyway was focused on the original order. What matters is whether the order is to be characterised as we suggest. And if it's a question of drafting, then the drafting can be altered. And the evidence obviously may have gone to a wider formulation. I've already covered the adjourned hearing point, which we debated through the questions from Lord Justice Nugee. The other reason relied upon by the judge was that the application was ancillary to the trial judgment, not to the Part 71 order. That's at paragraph 113. It's not clear entirely what the judge meant by that, but we think there are three reasons why the judge's judgment on this is wrong, and that's set out at paragraph 49 of our skeleton. First, we say it disregards the purpose of the jurisdiction under Part 71, which the purpose of which is to enable a judgment creditor to enforce against a judgment debtor. So Part 71 is designed to secure enforcement of a judgment debt. And so any order ancillary to Part 71 will by definition help to secure the judgment debt. But the converse is not true. It doesn't follow that any order is therefore incapable of being ancillary or incidental to the Part 71 order. Secondly, as a question of fact, the bank's application requires a further examination of Mr. Vick to achieve the outcome intended by Part 71 and to serve the purpose of the Part 71 order. It's inevitable that the outcome will also help the bank secure the judgment debt. But the order sought is designed to do so by securing compliance with the original Part 71 order. Thirdly, it makes no sense, as the judge did, to say the order is ancillary to the committal order. The committal process has come to an end. The objective of the order sought is not to bring the committal order back to life, but to ensure the Part 71 order is complied with. The fourth additional reason relied on by the judge was that the order sought would involve a contravention of the double jeopardy rule. And she deals with this in 118 to 124 of her judgment. And her analysis is at 120, where she says the bank wishes to say that the order it seeks would be part and parcel of the original 2015 order, but asking the same questions with a clear agenda of pursuing him again for contempt would run contrary to the double jeopardy rule. And then she says there would only be a fresh contempt if there were a fresh order. Now, 3 points on that, my lord. The first is the case we've looked at, such as Wilkinson, established that a fresh contempt requires a fresh order to be made in the sense of a newly sealed order of the court. It doesn't mean that you have to get a fresh Part 71 order. It simply means there has to be a new date for compliance with which the contemner, the debtor, has breached. For the purposes of double jeopardy, a new order, i.e. the new date of compliance here, has to be made. It doesn't matter that the order relates to the same subject matter that the contemnor has already been convicted and sentenced for. So in Kamari, the defendant was committed for a breach of the original order in 1994 and served a 3-month sentence beginning 95. He was committed again for his continuing breach twice after, and Neil J at the time said that the second sentence of imprisonment was improper because if there is a breach of an order to do a certain act by a certain date, such as the delivery of goods, and that non-compliance is visited with a penalty, that breach can't be the subject of a further committal order. And that's not what we're seeking to do. We accept that we couldn't commit Mr. Vick on the breaches of the 95 order that Mulder J found him to be guilty of. And the same point is made in Borg and L. Zabadi, which is in the authorities bundle at tab 17. it is established by the authority of the Court of Appeal in Wilkinson that it is not illegitimate, contrary to principle, for a father who has served a sentence for breach of an order requiring him to cause the return of the children to the jurisdiction to be recommitted for breach of a later order seeking the same end, namely the return of the children. And the Court of Appeal upheld that order. That was at tab 21 of the authorities bundle. Mr. Vick accepts, by reference to that case, that a breach of an order can be made in a breach of an order made in materially identical terms to the former order can be punished by committal, and that's in his skeleton at paragraph 69. So the point is that there is no double jeopardy with the limitations that I have just outlined, and in any case, the judge's reliance on the double jeopardy principle is premature because it doesn't preclude a further examination. It would preclude the bank from seeking to commit Mr. Vick for breaches of the further examination if there was duplication with the order made by Mrs. Justice Mulder. And that is something that would have to be assessed at the time. Mr. Vick's position that the court can't make an order that it can't enforce is a highly unattractive one because it's a submission that assumes Mr. Vick will breach any order for a further examination or will lie. We at the moment think the court should be assuming Mr. Vick may turn up and give the information. That was something he suggested he would do. So the question may not arise in any event. My lord, those are my submissions on ground one, subject to the respondent's notice point, which is on territoriality. And this was the subject of Mr. Vick's skeleton argument at paragraphs 57 to 66, where Mr. Vick argued that the court had no inherent power to order an examination of the judgment debtor. And he says his power derives solely from the CPR, and the CPR power doesn't have any extraterritorial effect. And he relies on the Raja case and the Masri case. We address this argument fully in our supplemental skeleton, so I won't take up too much time on it. But there are two flaws in the argument. The first, as we explain in our supplemental skeleton at paragraphs 3 to 4, is the argument attacks an argument we are not making. We are not asking the court to exercise a freestanding inherent jurisdiction de novo to require an officer or a former officer to attend for examination from abroad. So it's not a fresh taking of the jurisdiction, which is what the argument assumes. It's the exercise of existing jurisdiction conferred by the valid service on Mr. Vick when he was in the jurisdiction. And the judge recognised this point at paragraph 86. So if that's right, and that's the argument we're making, and either the court thinks we're right on that or not, but we're not suggesting the court can now, within its inherent jurisdiction, make a fresh order on Mr. Vick. And on that basis, Raja has no relevance at all. In any case, and this is the second flaw, Mr. Vick's argument misconstrues the principle in Raja, which was expressly considered, this case was expressly considered by the Court of Appeal in its 2018 jurisdiction decision, the one of Justice Gross, at tab 28 of the supplemental bundle. And at paragraph 36, the judge held that the principle from Raja is that the court's general inherent jurisdiction cannot be used to lay down a procedure that is contrary to or inconsistent with the CPR. But again, there's nothing in the application we're making that is inconsistent or contrary to a provision in the CPR. And none of the cases relied on by Mr. Vick at paras 63 to 66 of his skeleton, which we address in paragraph 9 of our supplemental skeleton, take his argument further. That takes me, my lord, to ground 2, which is the judge decided that even if she had the power to order a further examination of Mr. Vick, she should not exercise her discretion to do so. And her reasoning is at 131 to 143 of her judgment. And we accept that in order to overturn that decision, we need to show the judge's error was a serious one that caused the decision of the lower court to be unjust. And that's the Tanfern case at paragraph 33, tab 5 of the authorities bundle. And we say that test is plainly met. Essentially, at paragraph 131 of the judgment, the judge held that a further order would be an empty gesture or a futile pursuit. And she relied on two propositions in support. So first of all, she said that even though the evidence showed that Mr. Vick continues to have a real role in SHI and is likely to have information relevant to the enforcement of the judgment, that was not enough because the history of the proceedings showed he was more likely not to comply, and we would probably not get anything out of him in cross-examination. So that's 133 to 138 of her judgment. Secondly, she said that because the bank was not seeking further documents from Mr. Vick, had not previously sought a further examination of Mr. Vick and had made submissions opposing suspension of Mr. Vick's committal, she thought that evidence, the bank thought they wouldn't get anything, and that's paragraph 141 of her judgment. And I'll address you on both of those reasons, and also Mr. Vick's argument that the bank is pursuing the further examination for an improper purpose, which is in his skeleton at paragraphs 80 to 82 and the respondent's notice. So, my lord, there are four reasons why the judge was wrong to conclude that the order sought would be futile. First of all, making the order in and of itself enforces the court's orders, upholds its authorities, and protects the integrity of its processes. Mr. Vick is undoubtedly in flagrant breach of the Part 71 order, so the choice before the judge was stark: either to enforce the court's orders against Mr. Vick and uphold its authority, or to give up in the face of his campaign of non-compliance. And the exercise of her discretion engaged the very strong public interest in upholding the court's orders emphasised by the Court of Appeal, as you've seen. And I'll also come on to show you a decision of Mr. Justice Bryan in these proceedings. Secondly, Mrs. Justice Mulder, the Court of Appeal, in upholding Mrs. Justice Mulder's decision, Mr. Justice Henshaw and Lord Justice Males all considered or appeared to consider a further examination of Mr. Vick to be a worthwhile exercise. And none of those judges thought it would be pointless or futile. Mr. Vick says all this shows is a disagreement between the judges, but when combined with the strong public interest in enforcing the court's orders and the substantive flaws in the judge's reasoning, which I'll come on to, it's important to balance the views of all of those judges, particularly Mrs. Justice Mulder, who heard Mr. Vick give evidence and for these purposes was the trial judge. Thirdly, the judge should have proceeded on the basis that Mr. Vick is more likely than not to attend a further examination, because his consistent track record is that he has done. He attended the trial for evidence, he attended CPR 71 examination, and he attended the committal trial remotely. He also said he was going to attend a further examination if it was remote. He only decided not to attend the further examination after establishing his suspension had expired, and therefore he said he was under no obligation to do so. The judge also recorded in her judgment at paragraph 22 that Mr. Vick's stated position before Mrs. Justice Mulder was that Mr. Vick intended to comply with any such order by attending and answering questions. Mr. Vick's leading counsel, as I've already said, emphasised that he would comply, and Mr. Vick's current counsel does not suggest Mr. Vick would breach a further examination order if it were made, and Mr. Vick has not served evidence to suggest that would be the case. And in fact, my learned friend Skeleton criticises the bank for suggesting Mr. Vick is threatening to disobey any further examination order if made. That's paragraph 76 of his skeleton and paragraph 12 of his supplementary skeleton. So Mr. Vick's stated position is that he intends to comply with any order made. May I also show you the judgment of Mr. Justice Bryan, which is at the supplementary bundle at tab 31, please. this was the application made by Mr. Vick at a time when, in fact, his committal order had expired, but at the time when he hadn't realised and thought he was under an obligation to attend the examination. And he applied to attend remotely. In paragraph 61, which is on the first page of this extract, Mr. Justice Bryan refers to the submission Mr. Vick made on that occasion if he was ordered to attend in person. And he says the bank would lose its opportunity to question Mr. Vick about SHI's assets. That's what it was said. That was a submission made by Mr. Vick as to what would happen if he didn't give the remotely. And at paragraph 62, it is said, it's important to note that nowhere in the evidence of Mr. Clark is it suggested as asserted that Mr. Vick will not attend if ordered to attend. That comes, as far as I'm aware, for the first time in the skeleton argument, and no evidence has been put in support. And the judge goes on to say, I do not consider that the terms of the application notice supported by a statement of truth begins to amount to a statement that Mr. Vick will not attend in this jurisdiction if he is ordered to do so. And then if you look at 64, he says the starting point is that there's been a committal order which sets out the terms to be complied with. He's purported to comply with those terms in relation to disclosure. And there's no admissible evidence before me that Mr. Vick will adopt a different approach, either with the committal order or in any order I make this afternoon in relation to his attendance in person. And it was suggested that the bank would take steps to prevent his departure. And again, that was not accepted as a reason to accede to Mr. Vick's application, and 93, it was rejected, similarly 94. And sorry, Mr. McDonald's pointed out that the judge said in paragraph 62, I consider it would be bowing to blackmail if I simply accepted that Mr. Vick wouldn't come. And we say the position is even stronger here because, again, there's no evidence, and the court has seen that Mr. Vick so far has attended. And my lord, the fourth point, and the fourth reason the judge's approach was wrong, is that the evidence shows Mr. Vick continues to be able to give instructions and directions in respect of SHI and has an ongoing involvement in its affairs. My lord, the evidence for this, my lord, is that in Mr. Robinson's 10th witness statement, at paragraph 45, and I'll give you the references, the supplementary bundle, tab 9, page 56. So since the examination before Mr. Justice Cook, Mr. Vick has produced 460 pages of documents which go to SHI's interest in Devon Park, and Devon Park is a biotechnology fund in which SHI held an interest, and it's one of the areas which Mr. Vick would be questioned on, and he's not been questioned on. Mr. Robinson also explains at paragraph 50 that the bank has obtained 5 boxes worth of new evidence from Mr. Olaf, who is connected to Mr. Vick, and again, Mr. Vick's not been questioned about it. And the judge herself accepted the bank's submission at paragraphs 133 to 135 of her judgment, that the evidence shows Mr. Vick has recently been involved with SHI because in 2019 he was active in seeking an expert for proceedings in Norway and giving instructions to find a compliant lawyer who would do what SHI wanted. And those proceedings are still ongoing. in 2020, he was still regarded as a key contact for SHI by its lawyers and corporate service providers in the Turks and Caicos. And there was evidence showing that there were regular business communications between Mr. Vick and Mr. Olav, and Mr. Olav is a RAND, which owns 100% of the shares of SHI. Now, all of that was in fact accepted by the judge in her judgment based on the evidence of Mr. Robinson. So there's a clear basis to assume that he still has an ongoing involvement. And there's also a clear reason to assume that an examination would lead to some fruit. So, for example, Mr. Vick, through his cross-examination, revealed assets of Beatrice, a company he was using, and the bank was also able to establish that the Devon Park sale agreement purporting to sell SHI's interest was not bona fide through cross-examination of Mr. Vick. So testing the position with Mr. Vick does or has borne fruit, and the exercise of enforcement hasn't been in vain because the bank has managed to enforce an asset it discovered and recover approximately $60 million from that.
60.
60. And so what we can say is this is an ongoing, albeit slightly protracted, exercise of enforcement. It's not defunct. The bank is still enforcing this judgment, which it is owed and has been owed for a long time. And Mr. Vick has, in the past, provided information that has enabled enforcement at the trial and so on. So to say that there is no utility, we suggest, is just plainly wrong. And in any case, we think it is not the right approach for this court to say that a contemnor has been so uncooperative and evasive that there's no point carrying on because he'll just continue to lie.
Well, there may come a point at which that's a legitimate stance to take, that repeated examinations take up the time of the court.
Indeed.
There are other court users to consider. You would say you haven't reached that stage in this case.
We
But,
haven't, my lord. And
one can conceive of circumstances
that's right.
in which futility would be a sound argument, notwithstanding that it might be characterised as thumbing one's nose at the court.
Indeed, I think that there are passages in Wilkinson that say as much.
Exactly. But that's why, in a way, I wanted to show you Wilkinson also for that reason. It took in Wilkinson and Kamari, I think, 3 or 4 stints in prison, and it still wasn't considered futile. Now, I appreciate the subject matter of that may have fed into that reasoning, but here this would only be the second examination. So it's not, and that's in a situation where there is missing information identified. So it's a very different circumstance. And may I say, I think the judge was influenced to some extent by the fact that this litigation has been ongoing since 2009, and there have been repeated applications to the Commercial Court and the Court of Appeal. But that is because Mr. Vick has challenged every single aspect of this process, and often there have been long delays through listing. And so one can't suggest that that is indicative of the amount of time it's taken to enforce the judgment debt. Every point on jurisdiction that could have been taken has been taken. And that's not part of the enforcement process. It's on the route to the enforcement process. My lord, the respondent's notice takes the point that the court shouldn't exercise its power to order a further examination because the bank's purpose in seeking the order is improper. And it's said to be improper because the bank allegedly has the collateral purpose of using this order to launch further committal proceedings in the future. So that's the respondent's notice, which is in the core bundle at tab 3, and Mr. Vick's skeleton, paragraphs 80 to 82. There's no basis for that allegation, and it's not an improper purpose or an abusive process. The submission was made to the judge below, and she made no such finding. The best that Mr. Vick can do is not point to a passage in the judgment where there was such finding, but say it's to be inferred from other findings the judge made. Now, that submission is not tenable The genuine purpose of the application is to obtain information from Mr. Vick, and the judge recognised that in her judgment on weight. She says that the application was directed to completion of the exercise under the Part 71 order to the extent practical. And at paragraph 109, she held that the application was limited to live issues, which were the topics on which Mr. Vick had been held to be in contempt. The scope of the application is limited, as we have already discussed. My lord, the second point is that it's designed as a means of setting up fresh contempt proceedings is unsubstantiated. Mr. Vick's case that there is an improper purpose is purely inferential, and he bases it on 2 points. He says the bank declined an offer by Mr. Vick to answer questions voluntarily without a further order. The second point he says is that in the bank skeleton, he says it said that Mr. Vick might be more willing to tell the truth if faced by a threat of immediate committal. Now, neither of those points supports the inference of improper purpose. The bank naturally wants to question Mr. Vick, backed by a court order, and the prospect of a sanction if he lies again as incentive, and there is nothing improper in that. And the point goes nowhere, and you'll be familiar with the Navigator case, a decision of this court in which the Lady Chief Justice, the now Lady Chief Justice, made the point that there is nothing wrong in parties seeking orders and orders for contempt. They're entitled to enforce their judgment debts. But in any case, the point goes nowhere because it's entirely in Mr. Vick's control to avoid contempt by turning up and telling the truth. The final point is that the judges who have ordered or thought a further examination would be appropriate have not in any way thought it would be abusive for the bank to seek a further examination, Mr. Vick. So, my lord, we submit that on ground 2, the judge did have a serious error to render the judgment unfair in the exercise of her discretion, and that that decision should be overturned. The final ground is service, and the point turns on a narrow question, this is ground 3, as to whether Breacher, Mr. Vick's solicitors, were on the record for Mr. Vick generally in respect of all matters arising out of the Part 71 order, or only in relation to the committal proceedings, which is what Mr. Vick contends. There is no dispute that Breacher received the application and that it was immediately brought to Mr. Vick's attention. And that's the Part 71 application. The short point on this ground is that if I'm right on ground 1, then the court retains jurisdiction over Mr. Vick under the Part 71 order, and any further orders made against Mr. Vick form part of the original 71 proceedings. Mr. Vick gave Breacher's business address for service on him in relation to those proceedings, and he has never qualified or withdrawn his consent to service on Breacher in relation to the same. Service of the application on Breacher was therefore valid. If I'm wrong on ground 1, obviously this entire ground falls away. We set out our position on ground 3 in my skeleton arguments at paragraphs 64 to 65, and we make 3 points there. The first is that CPR 70, Part 71 proceedings are proceedings for the purposes of CPR 6.23, and there is an obligation to give an address for service. Secondly, Breacher did not limit their representation of Mr. Vick to exclude the Part 71 proceedings when they came on the record for Mr. Vick. And thirdly, the bank was therefore entitled to serve documents relating to the Part 71 proceedings, including the present application on Breacher. So, my lord, the first point, this arises from the words of Part of CPR 6.23, which provide that a party to proceedings must give an address at which that party may be served with documents relating to those proceedings. And if you need the reference, it's in the White Book at page 275. That part of the CPR does not define proceedings, and there is no definition elsewhere in the CPR. The case law shows that the meaning of proceedings in a given part of the CPR depends on the context and purpose of the rule in question. And the point is quite obvious, but I'll briefly mention two cases on the topic. The first is the Privy Council in the case of GFN, which is in the authorities bundle at tab 11. The underlying facts of this case do not matter because I rely only on it as the principle. But in a nutshell, the question before the Privy Council was whether a creditor's appeal against the liquidator's rejection of their proofs of debt constituted proceedings under the relevant Claimant rules. And that's obvious from paragraph 7 of the report on page 282. The Privy Council unanimously held that the creditor's appeals were proceedings, which meant that the liquidator could seek security for its costs. And the first passage that I wanted to show you is at paragraph 289, page 289, paragraph 26. And it's the sentence about 10 lines down, starting on the other hand. An application which, although in interlocutory in form, raised issues as to the rights of the party, which were in substance independent of the issues in disputes in the parent action, would, in my opinion, normally constitute in substance proceedings for these purposes. And if we go forward to page 290, in the majority concurring judgment of Lord Neuberger, with whom Lord Roger, Baroness Hale and Sir Jonathan Parker concurred, you can see that they agreed at paragraph 29 with Lord Scott, and picking up at the last sentence at 31E, it must be right, at least as a general rule, that when deciding whether a particular application is an action, suit or other proceedings, or an action or other proceedings, the court must look at the substance of the application as opposed to its strict form. If you could then read, please, paragraph 32, Lord Neuberger found it relevant that the creditor's applications raised new issues that were not previously before it and were essentially freestanding proceedings, albeit within the context of the wider winding up proceedings. So the 2 points to take are from this case are that, first of all, the question of whether a court process constitutes proceedings for a particular purpose is a matter of substance, not form. And secondly, that it is relevant to that question is whether the court process brings new issues before the court that were not previously before it, and or gives rise to essentially freestanding proceedings. This case was then applied in Jones and Persons Unknown, which is in the bundle at tab 25. There's no need to turn that up. Both of the cases, GFN and Jones, are cases in the security for costs context, where it matters who is bringing the proceedings against whom, since only the defendant to a given set of proceedings can typically seek their security. There is a different meaning of proceedings in another context in the Court of Appeal decision of Gotti, which is in the authorities bundle at tab 26. And again, I only rely on this case for general principles, so I'll just briefly summarise the facts. the claimant sought and obtained an injunction by filing a form N16A, but thereafter failed to issue a claim form. The defendant applied to discharge the injunction. The claimant capitulated and consented to an order for its immediate discharge. The defendant then sought its costs. The claimant argued no cost order should be made because no claim form had been issued and therefore there were no proceedings. And that's set out at paragraphs 1 to 3 on page 6 to 8. Now, this was plainly a very unattractive submission, but it required the court to engage with the meaning of proceedings under the CPR outside the context of security for costs that we've seen in GFN. And if we go forward to 642 in the report, or the bundle rather, and look at paragraph 64, the Court of Appeal held that issuing an injunction application under Form N16A constituted the commencement of proceedings to which the CPR applied, and the court thereby obtained an active jurisdiction enabling it to make further orders. And the court applied a common sense substance over form approach to the question. And then if we go over the page to 643, if you could please read paragraph 67 and 68. So proceedings is not defined and means different things in different parts of the CPR. And the Court of Appeal considered the judge below to be correct when he said that proceedings is wider than just what occurs after a Part 7 or Part 8 claim is used. So a claim form is not required. And then at paragraph 69, the Court of Appeal held that the judge offered a simple and attractive formulation of his approach. The word proceedings includes all applications with which the court is seized and in respect of which it is being asked to make orders or where the court is being invoked to do something, i.e. in this case to grant an injunction. And the Court of Appeal plainly cited that approach with approval. So the CPR uses the term proceedings to mean any application for court order depending on the context. So these cases show the courts treating the term proceedings flexibly and not asking the narrow formal question of whether a Part 7 or Part 8 claim or some originating process has been issued. Mr. Vick suggests that GFN stands for the proposition that the commencement of proceedings requires some form of originating process. That's paragraph 84(1) of his skeleton. That's not right, and this authority demonstrates the point. And against that background, my lord, the question is what meaning of proceedings did the Rules Committee have in mind in CPR 6.23? And we suggest it must have a broad meaning intended consistent with the purpose of the rule. And that purpose is readily apparent once a party has been served with proceedings and the court has jurisdiction over them. The rules require they give an address for service in order to facilitate the service of further documents and orders for the case management of the proceedings. You may not litigate in England without doing that. And I can make that point good by reference to the recent authority in Tonstate and Wojcicki, which we cite in our skeleton at paragraph 71 and is in the authorities bundle at tab 24. This decision, I should say, postdates the judge's decision below. And it concerned whether a banker's trust order had been properly served on the defendant by virtue of service of his solicitors under CPR 6.23. And the facts are set out at paragraphs 1 to 2 on page 603. The banker's trust order was made against the party I called Jill, like the judge did, that required him to provide certain categories of information and documents. He breached the order and an application to commit was made. Paragraph 3 recites the issue that arose as to whether there'd been proper service of the banker's trust order. And at paragraph 6, your lordship can see the position in relation to service of the banker's trust application. It was issued and served in December 2023 with the hearing on in April 24. Jill initially acted in person, but then had a notice of change filed by Field Fisher shortly before the hearing on the 8th of April 2024, so it's served 2 days before the hearing. They gave their business address for service on Gill. And then if you could, and just to have that off, Mr. Justice Adam Johnson concluded service on Field Fisher was valid service. And if you could read, please, paragraphs 22 to 25 on page 606. If we could then move, please, to paragraph 29 on page 607. It's paragraphs 29 and 30 deal with whether a respondent to a banker's trust order is a party to the proceedings. And the judge concluded that Jill was a party to the proceedings because the court had jurisdiction over him. And the judge's reasoning is developed beginning from line 3 of paragraph 31. The English court's jurisdiction was not based on any submission in that sense. It was based on Jill having provided an address for service under the Companies Act, which was valid at the time of service on him. So the judge held that the banker's trust order commenced proceedings for the purposes of CPR 6.23 and that there was a party to those proceedings. And in my submission, there's no basis for distinguishing Part 71 from a banker's trust order. The position of a respondent to a banker's trust order, who's a third party who is required to provide documents and information to support the main proceedings, is very similar to that of a Part 71 officer who is required to do the same.
Would the same apply to a witness summons?
My lord, I need to think about that. I don't think so, but
So what's the distinction between a banker's trust order and a witness summons in terms of the subject matter that makes one of them proceedings and the other not? They're both orders that someone comes and provides information.
can I come back to you on that, my lord, in a moment? I just would like to think about that before giving you an answer off the cuff.
Yes.
Did Mr. Justice Adam Johnson consider whether he was a party, given, as my lord says, that the banker's trust order is really an order to provide evidence?
Paragraph 30.
Paragraph 30 and 31, my lord.
Yes, but that's a different point. That point is he didn't engage with the merits. And what the judge says is, well, that doesn't matter. The reason he didn't engage with the merits because he didn't want any order made against him to be enforceable in Israel.
But he makes a finding that he did remain a party.
Because
Yes,
of the address, because 623 required a person properly served with the banker's trust order to give an address for service.
That assumes that 623 applies to a banker's trust order.
Because the argument doesn't really seem to have engaged with that part. It's whether he ceased to be
Yes.
a party when he disinstructed his legal team. And you can certainly say this proceeds on the assumption that they were proceedings governed by 6.23. But is that addressed in turn?
What the judge found was so at paragraph 10, Jill was a resident in Israel and the court only had personal jurisdiction over him because he'd registered an English service address under the Companies Act, and the Bankers Trust application had been served at that address. The judge instructed his English counsel, the judge found that Jill had instructed his English counsel and solicitor team to play no further part in the proceedings, and the Bankers Trust order was then made with an order permitting service on Jill's solicitors, that's paragraph 12, and Jill sent a notice of change saying that the official had ceased to act on the 11th of April, and the order was sealed, which you see at paragraph 16, and the issue was whether the service of the order on field fishing was valid service, that's paragraph 19, and the judge found at 21 that the service was valid service because the notice of change was defective, I think.
It all is this right? I mean, it proceeds on the premise that if he hadn't disinstructed them, they'd come on the record in relation to this particular application, and there was never any question about whether service on field fisher would have been valid. So it wasn't really addressing the question as to whether they were proceedings in respect of which there was initially an obligation to give an address for service. Is that right? That's just it looks like to me.
I think so, my lord. I can't. He doesn't refer to GFN, but he proceeded on the basis that a person properly served with a Bankers Trust order was required to give an address for service. That seems to be the assumption within the judgment.
I mean, I hadn't looked at GFN before, and we went through it quite quickly, but it looked to me as though the first passage you showed us, which was quoting from Lord Justice Cotton,
Yes.
was drawing a distinction between something which engages a determination of substantive rights between the parties and other interlocutory matters, although I think it wasn't put as interlocutory matters, and certainly something which is a witness summons or designed just to obtain evidence for the purposes of deciding a dispute between other parties sounds rather as though it's on the second side of the line rather than being engaging the substantive rights of the parties.
Should we just look back at...
But I readily confess that I only got my eyes over the passage relatively quickly as you were on it. Tab 11, is it?
It was, tab 11. And the key passage was at 26, that I think you had in mind.
Yes. So 25, which we haven't looked at, which is where Lord Justice Cotton is drawing a distinction in two types. On the one hand, those which do not decide the rights of the parties, but are made for the purpose of keeping things in status quo, or for the purpose of obtaining some direction of the court, which will be done in the progress. And on the other hand, those who decide the rights of the parties, Lord Justice Cotton drew this distinction for the purpose of deciding An interlocutory application designed to regulate or assist in some way the conduct of the substantive action between the parties
And that's,
would not, in my opinion, constitute proceedings.
yes, and that, but ours, part 71 is not, then is not designed to assist in the conduct of the substantive action.
Isn't it? I thought the whole purpose was to gather evidence from a non-party to assist one
But it's
party
the
to enforce a
enforce-
judgment against the other
But
party.
the action, the conduct of something that the action has occurred, it's assisting in the enforcement of the judgment debt.
Which is a judgment debt owed by SHI, and it's not a judgment against Mr. Vick, and he is a quasi-witness for these purposes. He was at the relevant time an officer of the company, but it's not an order against the company that by its proper officer it provides information.
That is fair.
It's the particular, perhaps the slightly unusual provision, pragmatic provision, I think, as Lord Nance put it, that someone who is an officer can be required to come and give evidence about the company's assets.
Yes, but on the other hand, an application which, although interlocutory in form, raises issues as to the rights of the party, which were in substance independent of the issues in dispute in the parent's action. Well, Mr. Vick is saying this application raises issues about his rights independently.
In what way?
What rights?
In what way?
Well, he's saying that on the current application as to whether it is the ambit of it is appropriate for somebody who's no longer an officer, or what he's exactly required to do.
That's got nothing to do with that's should he provide you with evidence to assist you in enforcing a debt which is not owed by him but owed by SHI? Is that really what's being talked about by Lord Justice Cotton and by Lord Scott in this passage as something which assists the conduct of the substantive action between the parties? I would have thought it is.
I think, my lord, what's being said is you can draw that distinction, but here it's the use of the word originating application that seems to be the main focus in 32.
Well, there were proofs of debt, and obviously in an insolvency, that's quite an important, affects the substantive rights of the parties, if you use parties loosely, as all those who are interested in the assets of the company.
That's right, my lord, and that's in the context of security for costs, this case, as was Jones. But then it seems to be expanded, we thought, in Tom State, beyond that context.
Well, it may have been, but without apparently the point being specifically addressed, and without any reference to GFN that one can see.
I can see that. But you've also got Gotti, which I went to in paragraph 69. If we go back to... which is tab 26. This was the claim form. No claim form.
Gotti is about proceedings, but it's not about who's a party to proceedings, is it?
I think that's right, but it is about the definition of proceedings for the purposes of 623.
Well, I can see that it can be said that taking steps to secure might be said to be proceedings, but there is a separate question, which is whether someone who is engaged in litigation in a capacity as a witness can be regarded as a party to proceedings for the purpose of 623. And parties generally are the claimants and defendants, and that's what CPR 19 point 1 says that people can be claimants or defendants. And witnesses generally are not
But in a
parties.
But in a sense, my lord, the party here is SHI,
Yes,
and
exactly.
Mr. Vick is the embodiment of it.
But
So
he's not.
No.
He's not. I
Well,
mean, he's not being summoned as SHI. That's the point my lord just made. It's not
Yes,
SHI's who's being required to give evidence
But it is
through
this-
its officer.
it's
It's Mr. Vick personally.
it's Mr. Vick as the officer of the company. He is the judgment debtor for these purposes as the
He's not
officer
the
of
judgment
SHI.
debtor for- He's not the judgment debtor for his purposes. The judgment debtor is SHI. He's being summoned to give assistance by way of answering questions as to the judgment debtor's assets.
That's right. But he's not coming as a mere witness, he's coming as the officer.
Why is he not coming as a mere witness?
Because he's been summoned as the officer, so somebody who is
Who's able to give information? That's the basis on which he's being asked questions.
But if someone who is the recipient of a Part 71 order has, by the time they arrive, resigned and says quite truthfully, frankly, I have no idea what the affairs of the company are now, he's giving his own personal information. He's not giving the company's information.
well, if he's resigned,
Yeah.
yes.
So, but I use that to illustrate the fact that
Yeah.
it's not an order against the company. It's an order for him to provide such information as he personally has.
Yes,
He
but
has to have been a director in order to be amenable to that jurisdiction, but he's not giving evidence in his capacity as a director. That's the point my lord's making.
yes, but I think what I would say is he's coming because of his status as an officer. So Part 71 doesn't enable you to say such and such person was employed by the judgment debtor and therefore has useful information. It's an officer of the company.
Yep.
And so there's a status of that, and that's what I'm trying to
Company
press.
can only act through its
Exactly.
officers. A company can't act in any other way.
And so for these purposes, he is embodying SHI, the enforcement of the debt.
Well, I thought that was the point Lord Masry number 4 was quite keen to emphasise was not the position. It's not the company. I may be wrong, but that's how I read it.
But once you accept the Part 71 proceedings are proceedings,
Well, that's why I ask: is a witness summons proceedings? Because I'm not sure that an officer under Part 71 is different in kind from a witness who's asked to come and give evidence at trial.
well, can I go back to the Gotti paragraph at 69 as the first building block of this?
Yes.
So you see the formulation of the approach as to what applies, what are proceedings, which includes all applications with which the court is seized and in respect of which it's being asked to make orders. And when a party takes a course of action in order to obtain a remedy, these will be proceedings. And so we suggest the Part 71 proceedings are proceedings. Mr. Vick has given an address for service, which may be a point of distinction with a witness summons, and therefore...
No, because if you're right, the witness, and it is analogous, and if I'm right in saying it's analogous, then a witness served with the witness summons would be obliged. And I can see you can say that prima facie seems to be within the very wide formulation His Honour Judge Salmon set out in paragraph 69. Any application, all applications of which the court is seized, and in respect of which is asked to make orders. But I just that certainly moved a very long way from Lord Justice Cotton, if that's what's being said.
But, my lord, there may be a limitation on this, because if for a witness summons, you don't have to give an address for service, I think.
Why not?
Why not? But why not if there's
So,
there's an application with which the court is seized for you to,
Well, can I
evidence?
put it this way? In a sense, without ducking it, one doesn't need to decide that question, because here you've got Part 71 proceedings that would fall within this definition, and Mr. Vick did give an address for service as a party. Otherwise, there'd be no basis on which he needed to do that.
well, that's controversial. That's the second part of your
Yes.
submission, that what
he did,
what he did in
yes.
2017.
That's right, and I accept that. If they can show a limitation, then obviously that's not.
Or, well,
But my
whether
point
or not
is,
that's the right way of putting it.
Yes.
There is a separate question as to whether what he did was giving an address for service in relation to the Part 71 proceedings. But leave that on one side.
yes.
Were they proceedings which required an address for service to be given, which is, I think, the part we're on at the moment?
Yes, and my submission is yes, and it falls within.
It falls within 69 of
69
Gotti,
of Gotti.
even if it wouldn't fall within the paragraph we were looking at of
In
the Privy
GFN.
Council in GFN.
And the reason for that is GFN is focusing on security for costs, whereas Gotti is looking at other types of proceedings, and therefore is the appropriate test. But even you saw the movement even in the security for costs formulation, and then this is wider, and then the address for service point is in the Tonstate case. So I think, well, there are 2 points. One is it's form over substance over form, rather. And here we say if the Part 71 proceedings aren't proceedings, it's unclear what they are. And the second is that Mr. Vick is a party to those proceedings, which are more than simply analogous to a witness summons, and he has got legal representation and given an address for service. And applying the rationale in Tonstate, that is in itself an answer to the question of whether these are proceedings under party.
Right.
And my lord, it may be that because he's given an address for service, this debate doesn't matter. But I would suggest if I'm wrong on that, it would fall within 69 of Gotti, and then the address for service point in any event would be determinative following Tonstate.
So although you say this is the first question, you say this doesn't matter.
That's right. But I was trying to work through the different arguments that might be taken against me, but it doesn't. I would say when cut through.
If he's given an address for service in relation to this application, doesn't matter whether he was obliged to or not. And if he hasn't, it doesn't matter that he was obliged to. Because the only service has been on Brecher.
Yes, I think that's
So
right.
your case is the only relevant question is whether the notice that was given in 2017 was an address for service for Part 71.
I would put it.
Alright.
I would put it slightly differently. When there was a change of solicitors, was it suggested that they were only acting? They were limiting their representation in any way, and that's what I think Mr. Vick, we suggest, would have to show. And can I come on to that? So they didn't limit their representation on Mr. Vick to exclude the 71 proceedings when they came on the record. And although Mr. Vick argued this below, the judge made no factual finding as to that effect. the chronology of events, if your lordship could have this in front of you, I'm conscious of the time, is at the core bundle at tab 8, please. And at page 95, you see that in 2013, Mr. Vick was joined as a defendant for cost purposes only. And you had all the cost proceedings. And then in July 2015, over the page 96, you see that Mr. Vick was served with the Part 71 order in this jurisdiction. On the 24th of August 2015, he applied to vary or strike out that order, and he was represented by Cook, Young and Kaiden. And there was no doubt, therefore, that Cook, Young and Kaiden were representing Mr. Vick in relation to the Part 71 proceedings, as well as the non-party cost proceedings. And over the page, you see on the 11th of December 2015, Mr. Vick attended for questioning before Mr. Justice Cook pursuant to the Part 71 order, and Cook, Young and Kaiden was still acting for him, and he was represented by leading counsel. On the 24th of March 2016, Freshfield served the draft committal action on Cook, Young and Kaiden. And the committal action arose directly from the Part 71 order as part of the court's inherent jurisdiction to enforce that order. In May 2016, the bank filed an application for the service of the committal application on Mr. Vick. And in the context of the threatened committal, Mr. Vick moved his representation from Cook, Young and Kaiden to Taylor Vintners, and there was no suggestion that the scope of Taylor Vintners' representation of Mr. Vick was any different from or narrower to that of Cook, Young and Kaiden. And the same solicitor from Cook, Young and Kaiden, Mr. Clark, took the case with him, as he then did to Bretcher later.
So far as the 71 order is concerned,
Yes,
Cook Young
and Kaiden.
represented him in relation to some of the aspects. So far as the committal application was concerned, they declined to say they had permission to accept service,
Yes,
and there was an application to serve him personally,
yes.
and then
It
he
was-
instructed Taylor Vintners in place of Cook Young
And it was said there was an inherent, we didn't need to serve him personally because it was inherent within the scope of the Part 71 proceedings. That was the Mr. Justice Tier decision, and Taylor Vintner came on the record, so it could have been Young and Kaiden or it could have been Taylor Vintners. There was no change except in the identity. And the 16th of December, Mr. Justice Tier.
Sorry, so but Mr. Justice Tier's decision was there could be personal service on Mr. Vick of the committal application. Is that right or not?
No, that was,
No,
he
understood.
rejected that. What he said was we didn't need
You didn't need it.
it because it was an incident of the Part 71 jurisdiction and we already had jurisdiction over him.
I
So
see.
you didn't need to serve the committal application on him twice.
Exactly.
Right.
Exactly. We didn't
You didn't need an
applied.
address for service on him.
What happened was we applied for permission to serve Mr. Vick with the committal application because we thought he might take a point on it, and it was suggested that we couldn't do that by the methods we had suggested. But in fact, we didn't need to have permission to serve him because we already had the route of service through his solicitors who were acting for him, because it was all part and parcel of the Part 71 order that when it was served, and the court had thereby established jurisdiction.
So was
Okay.
it served on Taylor Vintners or on CYK?
I think the Part 71 was served on CYK, and the 71 order.
The committal
It
application.
looks from the top of the next page of the chronology as though, in relation to the committal application,
It
it was served on Brecker, but by way of service by alternative means, rather than because there was an entitlement to serve Brecker. But I'm only reading what's in the second
Yes,
paragraph.
that's right, because CPR Part 81 requires personal service.
Yep.
So it was served on his solicitors rather than on him personally.
Yes, I see.
So, as I say, the chronology is that the 71 order, as far as anything's an incident of the 71 order, that was served on his solicitors who took service and represented him. And so that's the issue. The committal, in a sense, doesn't really matter. It's the 71. And the reason to go through the chronology is that there are two changes of solicitors. One is Taylor Vintner, and it was Mr. Clark, I think, from CYK who moved to Taylor with Vintner,
Right.
and then he moved to Brescia, and that was in February 2017. And there's a notice of change of legal representative at the supplementary bundle at tab 6. And so the notice of change obviously is filed after well after the Part 71 order's been obtained and served. And it was served at a point in time when Mr. Vick had not fully complied with the Part 71 order. And that goes back to ground one. There is no limitation whatsoever in this document. All that Mr. Vick says is that, and this is at 88 of his skeleton, is that no one had any reason to believe the Part 71 order had any continued life or existence other than the committal application. But that is not right. The order was still extant, and he knew that he had not complied with it. And
What do you mean by the order was still extant?
the 71 order,
What do you mean by saying it's still extant?
that it's still a live order because it's not been spent through his compliance. He knew he had not complied with it, is what I mean.
What it required him to do was to attend and answer questions. He attended and answered questions, but he lied. In what sense is it still...
Because the obligation isn't to attend and answer questions, my lord. The obligation is to provide full information, and to that extent you are to attend court and provide documents. But the obligation is to provide the full information. So it is still extant.
So that the important bit of the 7th February notice of change is not merely that Breccia say they're being instructed to act on behalf of the second defendant in this claim, but they're doing so in place of Taylor Vintner's, and Taylor Vintner's had, as the successor to
Cook, Young and Kyden.
Cook, Young and Kyden,
And so
been acting as authorised representatives in relation to the Part 71 proceedings, if that's or
exactly.
process. Let's use
Exactly.
a neutral word.
And that's why I said it was for Mr. Vick to establish that there had been a limitation, because the clear position is that Cook, Young and Kyden were on the record for the Part 71 proceedings. Taylor Vintner stepped into their shoes, and then Breccia stepped in again. And so there's no doubt that Mr. Vick had solicitors on the record for him. And there's no suggestion that any solicitors, including Breccia, said
When you
they
say
wanted-
on the record, I mean they'd served the 71 order personally, and then he'd instructed solicitors and through them counsel. I mean, had they come on the record in the sense of his giving their address as the address for service in relation to the 71 order?
I will check. We will check that, my lord. And while I'm doing that, I'll just say that obviously there's no indication in the notice that Breccia's representation of Mr. Vick of this claim was limited, and they give their business address as the address to which the documents about this claim should be sent as the relevant address for service under 6.23. And that's just not addressed in Mr. Vick's skeleton. So, my lord, in the chronology, the Cook, Young and Kyden were on the record for the hearing before Mr. Justice Cook to vary or strike out the CPR 71 order and received, as I understand it, the varied CPR 71 order.
When you say on the record, did they give a notice that any documents should be served on them?
I'm taking instructions on that. We believe
Because, I
so,
mean,
but we should check it.
Because
to
there
be
is a
clear.
difference between
Yeah.
appearing, being instructed to represent Mr. Vick on those occasions, and being on the record. In the sense we're talking about.
Which we'll check, my lord.
Right. Yeah, we can come back to us on that.
Thank you. At paragraph 88 of Mr. Vick's skeleton, he relies on the words "for cost purposes only" in the box identifying the names of the defendants for the proposition, and to suggest that Brescia's representation was limited. But the non-party cost proceedings against Mr. Vick had ended a year before Brescia was instructed. The Court of Appeal dismissed Mr. Vick's appeal on the 21st of January 2016, and Brescia were not instructed until a year later in February 2017, and the Supreme Court refused leave to appeal in July 2016. So those proceedings were
And the
were
costs have been
over.
assessed by that stage, had they?
I don't know the answer to that. I think they're all going in one go to be assessed, but there was no further proceedings in
Well.
relation to costs. And the immediate context, in fact, of them coming on the record was the threatened committal application, which was an exercise of one of the incidents of Part 71 order, as Mr. Justice Tier found. And in fact, Mr. Vick accepts that Brescia were on the record for him in respect of the committal application, and that had nothing to do with his status as the party to the main proceedings for the cost purposes only, but arose from the breach of Part 71. The judge made that finding at paragraph 149 Roman 3 of the judgment. So the cost point doesn't help Mr. Vick. There's a further point about the period between February 2017, when Brescia came on the record, and May 2019, when the committal proceedings began. All of the hearings in that period, including the hearing before Mr. Justice Tier and the Court of Appeal proceedings with the decision of Lord Justice Gross, which we've looked at, were about whether the committal proceedings were an incident of the CPR Part 71 proceedings. So Brescia were representing Mr. Vick in relation to the precise point that they say they weren't on the record for, which is the scope of the court's inherent jurisdiction under the Part 71 order, which is the same issue we're debating today. So, my lord, that is why we say it's completely clear that Brescia were on the record, and it's hard, any argument they've raised isn't sustainable. I was briefly, conscious of the time, going to say something about the scenario in which you were with me on grounds 1 and 2, but find under ground 3 that there was no valid service.
Yes.
Now, service plays two roles in English procedure. It's the means by which the court obtains jurisdiction over individuals and entities, and it's the means by which steps in the proceedings are notified to the parties for procedural fairness. If there is an issue on ground 3, the consequence of a formal defect in service would be relevant only to notification. And because if I'm right on ground 1, the court undoubtedly has jurisdiction over Mr. Vick to make the order sought. So service isn't required to establish that jurisdiction. So the consequence of service on Brescia not having been valid is that there would be a procedural error with service of this application, that procedural error has had no consequences for Mr. Blick and caused him no prejudice because he was aware of the application shortly after it was served on Brescia and has contested it and this appeal with representation, and he doesn't suggest he's been caused any prejudice. So if there was a formal service issue, which we don't think there is, it can be remedied with an order dispensing with or retrospectively validating service. And alternatively, it could the bank could regularize the position by seeking an order from the commercial court in those terms. And it's difficult to see why it wouldn't be granted where this court would have held, assuming you're with me on ground one,
But
that jurisdiction's not an issue.
Is that part of your grounds of appeal and relief you're seeking from this court?
No, we would apply to the court below if that was an issue. I'm just saying it shouldn't, it wouldn't mean that the appeal was unsuccessful.
Well, we may, in those circumstances, have to address whether the application for permission to appeal was properly served. But you've got your separate point on that there was the application to strike out,
Yes,
which the court below dealt with and which specifically gave Brecker's address for service of
exactly,
that. And that must apply to any appeal from the determination on that question.
exactly.
Yeah.
My lord, what I didn't do, and I just want to give you the references because I've gone over, is just to tell you what the judge, give you what the judge found in a nutshell. So the judge dealt with service briefly at 150 and 151, and she made an error there because she said that Masri makes it clear that an application under CPR 71.2 is not a claim form and does not commence proceedings. But that is an error because Masri is not authority for that proposition, and it doesn't at that point. The House of Lords there was dealing with a different point, which is whether there was a jurisdictional gateway for service out of a Part 71 application on someone who's not already subject to the court's jurisdiction. So, my lord, you can see the passages cited by the judge at paragraph 276 of the bundle, the authorities bundle, is paragraph 26 and 16 to 17, and they just don't support what the judge is saying. And the second error the judge made in 151 of the judgment is the assumption that the question of whether there are proceedings depends on the Part 71 order being a claim form. And I've shown you the authorities, such as I have it, on that. The second point is that the judge held at 152 that a Part 71 director is not a party to the proceedings, but akin to a mere witness, but she did so on the basis of Masri. But Masri was making the point that a Part 71 director is not a party to the main proceedings, but it says nothing about the director who has been made a party to Part 71 proceedings being a party to those. And then thirdly, the judge...
What Lord Mann says is, I regard the position of such officers as close to that of ordinary witnesses. That officers of company being compulsory wound up with the court. So he is treating the Part 71 respondent as akin to a witness.
But that's because the question was whether they were a party to the main proceedings. And he says, no, they're not. But it doesn't answer whether, when they've been made a party to Part 71 proceedings by the proper service of a Part 71 order, whether they're a party to those proceedings. And so Masri doesn't make the point the judge found it did. And then the third point is about the scope of representation at paragraph 151, which I've addressed you on. But what I would just say is if you look at the judge's findings there, she relies on Masri for propositions that it doesn't support, either because it just isn't the right case. I think she may have got confused with a different case, or for the second reason that my Lord Justice Nugee pointed out, we would say Masri doesn't support the finding and the terms made by the judge.
It would be very surprising if she'd got the wrong case, because Masri number 4, 26 and 36 does.
We think, my lord, the judge may have had in mind the case of Vitol.
Which was approved in Masri.
Do we have it all?
Yes. Yeah,
Yes,
I'm
we
pretty sure
do.
we do.
Because it isn't Masri.
Tab 6.
So, my lord, the passage cited by the judge is at page 279 under tab 10. So that is good. Paragraph 26. Sorry, 276, I beg your pardon.
279, paragraph 36.
Yes, paragraph 27, bundle 276, paragraph 26. This is the passage on the mere witness point between the letters D and E. And Lord Mance is explaining that the English court does not get jurisdiction over the director of a corporate judgment debtor under CPR 21 by virtue of his existing jurisdiction over the corporation. So he's distinguishing Part 71 from the court's extraterritorial jurisdiction over an officer of an English company being wound up. But he's not considering the question of whether someone who is properly served with a Part 71 order becomes a party to the Part 71 proceedings. The second passage cited by the judge is at 279 of the bundle. In this passage, Lord Mance approves a judgment of Mr. Justice Tomlinson in Vittle, where the judge, Mr. Justice Tomlinson, held that CPR 6.302 was limited to documents served on parties to the proceedings, and so it didn't extend to service of documents on an officer of a judgment debtor under CPR Part 71, because the officer's not a party. That's not relevant because it's not concerned with the position where the court already has jurisdiction. Masri number 4 at 36 does not contain the words claim form or say anything about whether a CPR 71 order is a claim form, contrary to what the judge says.
No,
at
Lord
51.
Mance says that Mr. Justice Tomlinson was right. That's clearly what she's referring to.
But it's Vitol at 9 for this proposition, saying it's implicit in the holding in 9, presumably because the submission, that's Mr. Vick's case, was that it fell within the words any other document. That finding that was approved by Lord Mance in Masri at 36. Vitol at paragraph 9 doesn't say anything about whether a CPR Part 71 claim is a claim form or not. It's limited to whether CPR 632 allows for service of documents outside the jurisdiction on non-parties. So neither court, neither Masri nor Vitol, considers whether a CPR Part 71 application or order could be served out as the claim form, or whether it involves the commencement of proceedings where it is permitted. And Masri also didn't consider the question of whether the CPR 71 order was a claim form or whether it commenced proceedings. It was concerned with a different point. So if you look at 9 in Vitol, in the submission I've just made, that's in Authority 6 at page 101. My lord, I'm conscious that of the time, and I'm conscious I went very fast there, but
Well, you were interrupted a certain amount.
is there anything else I can assist the court with?
Anything else? No, thank you.
Thank you.
Well, Mr. Beswetherick, if you want to start for 2 minutes, do, but you may want to come back tomorrow morning.
Thank you, my lord. Thank you, my lady. There is one point that I wish to raise, or rather my learned junior, Mr. Hamilton, will raise. He's going to be addressing on ground 3 on service. I understand from the notes he was passing to me that he has a point that he needs to raise in light of the submissions that have been made. If I might then hand over to him in the remaining time just to address that.
Yes. Mr. Hamilton.
My lords, the point relates to a number of questions of fact that my learned friend was seeking to make in the most recent submissions in relation to whether Mr. Vick had given an address for service in relation to Breacher's address or prior to Breacher, Cookyoung and Keaton or Taylor Vintners. Now, to the best of my knowledge, my lords, none of that evidence is in the bundles before your lordships, and to the best of my recollection, none of it was in evidence before Mrs. Justice Cockerell. So far as I'm aware, a great deal of what my learned friend was saying in terms of the evidence that was being given from the bar is not correct, or at least is not the full story. Now, my lord, we're in some difficulty as to how to deal with that. If I'm to rebut those points, or if my learned friend is to be permitted to rely on them, unless I'm to turn up tomorrow with the relevant documents to address those points of fact, which are now being taken against me, it's not really clear how they are to be answered.
Well, as I understood the main point of fact, maybe I'd misunderstood it. It's the submission that they were on the record, that's to say the preceding solicitors, Cookyoung and then Taylor Vintners, were on the record in the sense that they had been authorised to accept service on behalf of Mr. Vick in relation to Part 71. And if she's going to produce some documents that establish that, well then let's wait and see what comes forward, and you can be forearming yourself to the extent you're able to make submissions about whether you are or aren't in a position to deal with it.
Yes, my lord. But to make clear that, my lord, I mean, my position would be that my learned friend wishes to identify the documents which she says are in the bundle before your lordships now, and which were in evidence before the judge, then she should do so. If my learned friend wishes to rely on any additional documents which were not before the judge, then she should make an application in the proper way to do so. But I think your lordship is saying that the onus is on her to make good those points of fact, because your lordships weren't taken to any documents other than the notice of change from 2017.
Well, I think what I'm saying is, let's see what comes forward. At the moment, she hasn't shown us anything.
Yes, my lord.
If she seeks to do so, then she'll need to have given you full forewarning and produced it to the court by first thing tomorrow morning, and then we'll see where we go from there.
I'm very grateful, my lord.
Any problem with that, Mr. Ladies? If you're going to refer to anything by way of documentation,
yes.
which isn't in the bundles,
Yes.
you'll have to identify it and
Yeah, and also one has to remember Mr. Vick has put his arguments on the basis that the representation was limited on the basis that I've identified the cost purposes. So in a sense, for his argument, it doesn't really matter.
Well, let's not rehearse the argument before we've seen what it is that you're going to be seeking to rely on.
Indeed. Okay.
10:30.
All rise in favour.